I realize, however, that the twin desiderata of a reformed judiciary and a revitalized legal profession must be directed towards much loftier objectives. In the grander scheme of things, these objectives are to safeguard the people's liberty and to nurture their prosperity, while upholding the rule of law and the independence of the judiciary. Upon these standards, I anchor my incumbency and stake my Chief Justiceship. In exercising the power of judicial review, or the authority of the courts, to pass upon the constitutional validity of the acts of the other departments of the government in proper cases, my personal judgment will be, as it has always been, guided by two standards of judicial policy, as follows. One, in cases involving civil liberties, the scale should weigh heavily in favor of the poor, the oppressed, the marginalized, the dispossessed, and the weak, the same constituency that Manila Rotary works for. Two, in conflicts affecting prosperity and development, deference must be accorded to the political branches of government, namely the Presidency and Congress. Allow me to explain briefly these twin standards or policy of my incumbency. Springing from our people's struggle for respect of human dignity, our 1987 Constitution mandates the protection of civil liberties, especially of the poor and marginalized. The Bill of Rights spells out in great detail and with crystal clarity this fundamental principle. When pitted against the enormous powers of the state and of government institutions, individual liberties must be fully safeguarded. Every court has the duty to provide the weak and the defenseless the vigilant protection they deserve. As the late President Ramon Magsaysay once said, those with less in life should have more in law. Our Constitution is so protective of human rights that it even armed the Supreme Court with quasi-legislative powers, if I may quote the Constitution, to promulgate rules concerning the protection and enforcement of constitutional rights, unquote. On the other hand, I believe that courts must be deferential to the political departments of government with respect to economic and social issues, as well as policy determinations. In my book, Leveling the Playing Field, I underscore the balancing role of the judiciary in our government. And I said, I quote, the Supreme Court safeguards not only food, but also freedom, not only jobs, but also justice, not only indulgences, but also integrity, not only development, but also democracy, not only prosperity, but also peace, unquote. As a rule, the Supreme Court respects the actions of the other two departments of government. In case of doubt, it will always uphold the constitutionality of legislative and executive acts and give the benefit of the doubt to Congress and the President. This stance is evident particularly in cases dealing with economic policies, which are within the authority and competence of the executive and legislative departments. In their task of nurturing prosperity, therefore, courts must give the political departments of the government reasonable leeway. They must respect the wisdom of their actions. To be sure, the grandness of the vision must be matched by measures that ensure the delivery of impartial, fair, and speedy justice, and more significantly, those that make the judiciary more transparent and more accessible to the people. I have repeatedly announced before the media, and I'm saying it again now, I will continue the judicial reform program started by my predecessor, Chief Justice Hilario G. David Jr. However, on top of the ongoing programs and projects under the Supreme Court's Action Program for Judicial Reform, my short-term agenda for the year 2006 focuses on the problems I have codenamed ASIP. A for limited access to justice by the poor, C for corruption, I for incompetence, and D for delay in the delivery of justice.